So today, this class is designed to go line by line through the purchase and sale agreement. We'll talk about some different scenarios. Feel free to ask questions, and if you have a question, just get my attention somehow. So your purchase and sale agreement, don't forget to put in your offer date. One of the things that, is kind of embarrassing, really, but it was probably, I was in real estate for a couple of years before I realized that the front key terms and conditions where it says A1, purchase and sale, coordinates with everything that's in here where it says B, purchase and sale, and then it goes into the description. So anyhow, just a little tidbit in case anybody else was like me who took forever. I'd go through a contract over and over, not realizing that it was very easy to get to the point that I was actually looking for. So the sign-in sheet's right back there too. Okay, so key terms and conditions, purchase and sale. The undersigned buyers agree to buy and the undersigned sellers agree to sell the real property described below, including all fixtures, improvements, and landscaping therein, property, on the terms and conditions set forth in this agreement. Property identification, you have your address, city, county, zip, MLS number, tax parcel ID number. Is that enough for a purchase and sale agreement? Nope. You have to have a legal description. So check one of the following. You have 1, 2, 3, and 4 attached as an exhibit. If you're going to attach it, you can go to gsccca.org and pull them up directly. It's always Exhibit A. If it's a condominium, you would do number 2. Number 3 is the same as described in deed book and page, or you can fill out all of the information for the property. If you select number 4, come on in. Do not forget to put the plat book and page. Come on in. There you go. Now, another note is where you see the little check boxes, don't forget the little details. If you don't check the box, it is not part of the contract. So that goes for every place that you see all the little boxes. And is super important when you're filling out things like your commission. If the box isn't checked next to it, if you have exhibits, which we'll get to at the end of it, and you have Exhibit A as the seller's property disclosure, but the little box isn't checked, it is not part of the contract. So be careful with all the little details. Excuse me. Your purchase price for the property to be paid by the buyer. Number 3 is seller's monetary contribution towards buyer's closing cost at closing. So this is how much the seller is going to contribute. We'll get into this a little bit more into detail, but what can be used for the seller's contributions? What can the buyer use that money for? They can use it for closing costs. Can they use it for your commission? Yes. They can cover, if they have $5,000 in closing cost, and your buyer brokerage agreement says 3%, but the seller is only offsetting their obligation by 2.5%, they can pay the other 0.5% out of their closing cost. Closing date and possession. The closing date shall be blank with the possession of the property transferred to buyer. Check 1, either upon closing or blank days after closing at blank o'clock, a.m. or p.m. If you select the second one, you're going to need to attach the temporary occupancy agreement. Number 5, closing law firm and the phone number. I love that they added the phone number. Side note on wire fraud. Wire fraud happens all of the time. All it takes is somebody emailing the closing attorney, and as soon as they get the response, they now have what the closing attorney has as their signature, right? Then they will create, instead of Frick's Law Firm, they won't hack the email. They'll put Frick Law Firm, create a whole new email with one less letter or one changed letter so that it looks similar. They copy in their email, the whole signature, so it looks like it's coming from them. So when your clients are asking you about wire instructions, whatever, my advice is to stay out of it completely. Send them to whoever they're getting the wire, whoever they're sending the wire to. But here's a key note to make sure that all of your clients know. Don't get an email from a closing attorney and go back to that email and use the phone number, because when they copy that signature in the fake email, they change the phone number to their phone number, right? So when they call to confirm, you're actually calling the person who's scamming you out of money, and they're like, yep, these are our instructions. So tell them, 1, off of the contract, or 2, Google it, and call them directly from Google. Holder of earnest money. If holder is the closing attorney, an F510 must be attached as an exhibit, and the F511 must be signed by the closing attorney. A side note, if you have an attorney who is going to hold the earnest money, the F511 is super important to have that done as soon as it goes under contract. If you wait, it will create a very complicated mess. So you have in your contract that Frick's Law Firm is holding $1,000, but you don't get the F511. The F510 says what has to be put in there is an alternate holder, and if it's not signed and returned by the closing attorney, the alternate holder automatically becomes the holder. Nothing else has to happen. It's automatic, which now means, let's say I'm the alternate holder. Now I'm responsible for the money, but the money's already been sent to Frick's Law Firm, and now there's a dispute. Somebody's terminating a contract. Both parties want the earnest money. I don't even have the earnest money, but I'm the only one who can write a 10-day letter. So you see the mess that it creates. So make sure, if you have your closing attorney holding it, that you do both the F510 and F511. Excuse me, I'm so sorry about this cough. Number 7, earnest money. Earnest money will be paid to the holder in a method of payment acceptable to the holder. Blank dollars as of the offer date, blank dollars within blank days of the binding agreement date, or C, which would be other. As long as the parties agree, make sure if you are spelling it out that it is very, very clear. I advise talking to your broker if it is anything other than 1 or 2, because lots of times intention is written, or they are written with good intentions, but what is actually written is not what the parties meant, or there are things that were left out that create bigger issues later. Number 8, inspection and due diligence. Due diligence period. Property is being sold subject to a due diligence period of blank days from the binding agreement date. What number should go in there?
7, 10.
Anything that the buyer and seller agree to. So of course, if you are the listing agent, you want that number to be as low as possible. If you're the buyer's agent, you're trying to protect them and trying to give them as much time as they can. But at the end of the day, it comes down to what the buyer and seller agree to. There is no right or wrong answer. Option payment for due diligence period. This is not used very often, but it really depends on the market that you're in, right? And how enticing your offer needs to be. This is a great option when your buyer is like, make this house mine, and you are up against competing offers. This is a very great tool to have in your tool bag. In consideration of seller granting the buyer the option to terminate this agreement, the buyer, one, has paid seller $10 of non-refundable option money, the receipt and sufficiency of which is hereby acknowledged, plus number two, shall pay directly to the seller additional option money of blank by check, ACH, or wire transfers of immediately available funds, either as of the offer date or within blank days from the binding agreement date. Any additional option money paid by buyer to the seller shall, subject to lender approval, or shall not be applied towards the purchase price at closing and shall not be refundable to buyer unless the closing fails to occur due to the default of the seller. So this is basically you paying for the option to be able to terminate. So you're paying for a due diligence period. Lead-based paint. To the best of the seller's knowledge, the residential dwelling on the property, including any portion thereof or painted fixture therein, was or was not built prior to 1978. If it was, you're going to need to attach the lead-based paint exhibit. There are lots of new things on the lead-based paint exhibit. If that needs to be filled out, make sure that, well, there's a lot. We're going to go over that in the next class with the lead-based paint. Yeah, that's a whole nother, sorry, that's a whole nother 20-minute lesson on lead-based paint. But the fine for doing your lead-based paint incorrectly is over $20,000 per missing initial. And that's not a fine from GREC. You can't just be like, just take my license. That's coming from the EPA. The fine's not going anywhere. You're going to have to pay it. Don't get fined. Make sure that everything in there, I mean, the fines are astronomical. You need to be very careful. This is what I was going to say about lead-based paint. If the property was built prior to 78 and needs a lead-based paint exhibit, the seller must fill out the exhibit before you need to have it signed at your listing agreement, because a buyer cannot make an offer without having that exhibit first. They cannot make an offer. Nobody can make an offer on the house until they see the disclosures from the seller. So make sure that it's done in that order. Brokerage relationships in this transaction. Buyer's broker is blank. This is going to be the brokerage, not the agent. And the seller's broker is blank. So you're going to put in the brokerage name. And then 1, representing the buyer as a client. 2, working with buyer as a customer. Don't forget your little boxes. 3, acting as a dual agent representing the buyer and seller. Or 4, acting as a designated agent where blank has been assigned to exclusively represent the buyer. So designated agent is where both agents fall under the same broker. So all contracts belong to the broker, which means your client is my client. If they are your customer, they're my customer. If they're your client, they're my client. So if you have a listing agreement and they're your client, and then another agent in your office has a buyer brokerage agreement and they're your client, that would be, since technically they're both my clients, they have to be designated. That's where you would put in your name as the agent. Number 4, acting as a designated agent where your name has been assigned to exclusively represent the buyer. So that is where the broker says, this agent is representing the buyer and this agent is exclusively representing the seller. So it keeps it out of the dual agency for the broker. Does that make sense?
So
That line is only filled out if number 4 is checked. Like,
Correct.
So is it the opposite? I mean, like, would they both be designated?
What do you mean?
Well, if one is the selling broker and one is the buyer broker, and they're
Yeah.
both in the same office, would they both be designated?
Yes, both of them would be designated, and each
Opposite.
agent's name, who is representing the seller and who is representing the buyer, would be written on those lines.
Like you and I, if we were to sell, it would be our names.
Sure, we both.
Yeah, but make sure that those are put in, because if you're just checking as a, that you're representing the buyer and they're representing the seller, and the broker is the broker for both of you, then you're going to get into a dual agency capacity. So just make sure that you use that. And then C, just so you know, we're on page 1, number 10C. Material relationship disclosure. The material relationships required to be disclosed by either broker is as follows. So this is where you're going to put in any, like if they're your spouse, if you are the one purchasing, when you're making an offer, does a seller care that it's your mother that you're representing? The
They
seller
could.
probably, well, I mean, are they not going to accept your offer? I mean, the reality is it doesn't really matter who you're representing them, right? But license law requires that you disclose it. So not disclosing will get you into a lot of trouble. It will make the contract voidable. There's so many things that can go wrong. It's not going to change though. Like you telling them that you're married to the buyer, like a seller's not going to be like, oh, I'm not going to sell this house to them then. Like they don't care. The seller doesn't care. So just make sure that you disclose. When it comes to disclosure, if you question it like, should I disclose this? The answer is probably yes. It is better to over disclose than to under disclose.
Tracy, if you've sold to somebody several times before, is that a relationship?
No. I mean, they can be your client over and over. You don't have to say, I've sold them properties before. Because at that point, then it would be like, well, what time frame, at how many? So no. If they are related to you, if you are the one purchasing it, obviously, or selling it, the same thing, whatever side it is. So no.
So just relative.
Yep. Time limit of offer. This offer set forth herein expires at blank o'clock, blank AM or PM on the date of blank. If you put in an expiration date, does it have to be there? No. But if you put it in and you say February 2nd at 5 p.m. and on February 2nd at 6 p.m., you get the contract back signed by the seller, is it a valid contract? Is it binding? No, you do not have a binding contract. Once it expires, it's expired. Basically, what they did by sending it to you after the expiration is give you a counteroffer. Now the buyer is going to have to accept the counteroffer. So make sure that you are keeping track of what the expiration date, if you use one, make sure that you receive it in that time frame, because if you don't, you don't have a binding contract. What was I getting ready to say about that too? The other thing to note is if you don't use them, and especially when you are in scenarios where buyers are going up against lots of different offers and they become very competitive. One thing that I see a lot of is a 0-day due diligence. They'll have $1,500 earnest money and 0-day due diligence. And what they say is, I'm still going to have the house inspected. I don't, but if I don't like the house, I'm willing to walk away from the $1,500 because that's what would happen. If the buyer then walks away, they lose the earnest money. And they're saying, to get my offer accepted, I'm willing to take the risk of losing my earnest money and putting a 0-day due diligence. What happens though is you submit that offer with 0-day due diligence. It's not accepted. They go on, they accept a different offer. Buyer goes on and gets into another contract. They're buying a whole nother house. And then the seller comes back and signs this contract and sends it back to you. And now you're binding, right? Does the buyer owe the $1,500 in that scenario? Yep. Just because it hasn't been paid does not mean that it is not owed. And there is no out. So that would qualify for them to get their earnest money back. So now they owe $1,500 to the seller. So be careful, because what is your client going to do if that happens? They're going to look straight to you. They're going to be like, how did you let this happen? You're paying the $1,500, not me. So be careful. And then, of course, your buyer and seller initials at the bottom. Further explanations. Purchase and sale warranty. The seller warrants at the time of closing that the seller will convey good and marketable title to said property by limited warranty deeds subject to zoning, general utility, sewer, and drainage easements of record as of the binding date, and upon which the improvements other than a driveway, and this was just added, wall, fence, mailbox, or walkway, do not encroach. 3, declarations of condominium and declarations of covenants, conditions, and restrictions of record on the binding agreement date. 4, any title objections raised by the buyer prior to closing, which the seller can satisfy and satisfy as set forth in the examination section below, or by which buyer waives. And 5, leases and other encumbrances specified in this agreement. Buyer agrees to assume seller responsibility in any leases specified in this agreement, and the closing date of the sale of the property to buyer shall not terminate any such leases. B, examination. Buyer may examine title and/or obtain a survey of the property and furnish seller with a written statement of title objections at or prior to the closing. If seller fails or is unable to satisfy valid title objections at or prior to the closing, or any unilateral extension thereof, which would prevent the seller from conveying good and marketable title to the property, then buyer, among its other remedies, may terminate the agreement without penalty upon written notice to the seller. Notwithstanding anything to the contrary contained herein, seller shall be deemed to have satisfied buyer's title objections if seller can deliver a good and marketable title. Sorry, I just lost my place. To the property, which for all purposes herein shall mean title, which a title insurance company licensed to do business in Georgia will issue at its regular rates, subject only to standard exceptions. So let's talk about this for just a second. Actually, let's read title insurance and then we'll talk about this. Buyer hereby directs any mortgage lender involved in this transaction to quote the cost of title insurance based upon the presumption that the buyer will be obtaining an enhanced title insurance policy if such policy can be issued on the property or for the buyer in this transaction. So if it is a cash buyer and okay, so let me just tell you, we had a scenario where a in your contract, you specify who is the closing attorney. The closing attorney is the one who will get the title insurance. This particular attorney, when they, do their research and all of that, the title company would not cover the enhanced title insurance for the for the buyer. So the seller comes back and says, wait a minute, I bought title insurance from another company. So he called them and they're like, yeah, we'll override this and we'll write the policy, but we have to do it with the second attorney. So the buyer says, no, I don't know what's going on with this property, but I don't feel comfortable anymore. I want out. Broker was arguing that the buyer had to move over in order to, they couldn't get out of the contract. No, you don't. Now, moving forward, what the seller would have done is put that they required that as the closing attorney. But they weren't the closing attorney, and your buyer does not have to change attorneys so that somebody will do a title insurance policy. If the closing attorney who is on the contract can't do the title insurance for it, your buyer can absolutely get out of the contract. Purchase price to be paid by the buyer. The purchase price shall be paid in U.S. dollars by such method of delivery acceptable to the closing attorney, including but not limited to wire transfer of immediately available funds. Where this agreement refers to the sales price, it shall mean the same thing as the purchase price. Don't you love that they have to redefine everything like that? Closing costs. The seller's monetary contribution toward buyer closing cost at closing. At closing, the seller shall make the reference seller monetary contribution, which buyer may use to pay any cost or expense of buyers related to this transaction, including without limitation any compensation obligations of the buyer. Buyer acknowledges that buyer's mortgage lender or lenders may not allow the seller's monetary contribution or the full amount thereof to be used for some cost or expenses. In such event, this is key, any unused portion of the seller's monetary contribution shall remain the property of the seller. So if this offer has $10,000 in closing cost and the lender limits it to $9,000, $9,000 is what the seller pays, and that $1,000 remains with the seller. Additional items paid by the seller. In addition to the above, the seller shall also pay the fees and costs necessary for the seller to convey good and marketable title to the property and the cost and fees of the closing attorney. 1, to obtain, prepare, and record title, curative documents, payoff, and estoppel letters. 2, for seller not attending the closing in person. And 3, to handle and deliver the seller's payoff and proceeds. So the seller is required to pay all of those fees. Items paid by the buyer. At closing, the buyer shall pay 1, the Georgia property transfer tax, 2, the cost of search, title, and tax records, and prepare the limited warranty deed, and 3, all other costs, fees, and charges to close or relating to this transaction. Prorations. Ad valorem property taxes. Community association fees, solid waste and governmental fees, and utility bills for which service cannot be terminated as of the date of closing shall be prorated as of the date of closing, notwithstanding any provision to the contrary. In the event ad valorem property taxes are based upon an estimated tax bill or tax bill under appeal, the party who paid less than their pro rata share of taxes to the other party at closing or collected more than their pro rata share of taxes from the other party at closing shall, upon the issuance of the actual tax bill or any appeal being resolved, promptly pay the other party the amount necessary to correctly prorate the tax bill. Did you guys know that? I don't see a lot of people do it, but it is definitely in here. In the event there are tax savings resulting from a tax appeal, third-party professional costs excuse me, to handle the appeal may be deducted from the savings for the tax year before reprorating. Any pending tax appeal for the year in which the property is sold shall be deemed assigned to the buyer at closing. The liability to the county and, if applicable, city in which the property is located for ad valorem real property taxes for the year in which the property is sold shall be assumed by the buyer upon the closing of the property. Buyer agrees to indemnify seller against any and all claims of the county and, if applicable, city for unpaid ad valorem real property taxes for the year in which the property is sold. Closing date and possession, the right to extend. This is getting fun. This has been changed, just so you know. How many of you guys knew that the right to extend prior to January 1st had an 8 p.m. deadline of closing? Many agents didn't even realize that there was an 8 p.m. Well, January 1st, so your brand new contracts, they took that one term because it was the only thing in all of our contracts that had an 8 p.m. time frame. They did take that back out, by the way. So now you have until 11:59. Right to extend the closing date. The buyer may unilaterally extend the closing date once for 8 days upon notice to the seller if either buyer's mortgage lender, including where the financing contingency has expired, or there is no financing contingency, or the closing attorney are delayed and could not fulfill their respective obligations by the date of closing, provided that the delay is not caused by the buyer. So that's key, number one. And with respect only to the extension resulting from the closing attorney being delayed and the seller has not already extended the closing date once for 8 days. The seller may unilaterally extend the closing date once for 8 days upon notice to the buyer if the seller cannot either satisfy valid title objections, including title objections that A, can be satisfied through the payment of money or bonding off of the same. So let's talk about that for a second. You get to the almost to closing, your days before closing, and you find out that there is a $10,000 lien on the property from a contractor who did work on the property. And the seller's like, I'm not even walking away with $10,000. I can't sell the property. Sorry. Can the seller walk away? Does he have the right to walk away? No. If it can be paid with money, he is still obligated to go through with the sale. He may need to go get a personal loan. But that lien has to be taken care of, and a lien can be taken care of with money. B, to do not prevent the seller from conveying good and marketable title, as that term has been defined herein, or the closing attorney is delayed and cannot fulfill its obligations by the date of closing, provided that the delay was not caused by the seller, and with respect to an extension resulting from the closing attorney being delayed, the buyer has not already unilaterally extended the closing date once for 8 days. So the key here is that if they are going to unilaterally extend, it cannot be for their fault. If a buyer has been requested from the very beginning to turn in their tax documents and they don't, can they use a lender delay because the lender has to have the tax documents? Can they use the lender delay to unilaterally extend? No, because the buyer is the one who caused it. So as a listing agent, you're representing your client and you're looking out for your client's best interest, which means if somebody gives you an 8-day unilateral, you probably need to get to the bottom of it, right? And figure out, one, because do you think that unilateral extensions are used incorrectly? All the time. So it is your job to figure that out. Of course, our goal is to get the buyer and seller to the closing table, right? But that needs to be your seller's decision. And if it's not supposed to be used, then the parties can agree mutually. They can extend mutually, but they can't use an 8-day unilateral for something that was caused by the buyer or seller. Keys and openers. At closing, the seller shall provide the buyer with all keys, door openers, fobs, access cards, codes, and other similar equipment allowing access to the property, the community, and the community amenities. In the event the seller is required to return the above items to a third party, the seller shall provide the buyer with the instructions on how to contact the third party to obtain such items. So your sellers need to be aware that if they have a pool pass that they have to turn back in, they are still required to give the buyer the instructions on how to get their own pool pass. Devices and fixtures. Except as set forth above, if a system, device, or fixture conveyed in the property, a device, cannot be operated without a specific controller, then not later than the time of possession, the seller shall provide the buyer with all controllers which are required for operation of the devices. Seller will also provide the buyer with all device credentials, including but not limited to the username and passwords for all devices, including access and guest codes, or the seller may request reset devices to factory default and provide the buyer with default credentials for all devices. Do you think this is key when you have a Ring doorbell, security systems? I would not recommend doing it as a here's all the passwords, because guess who still can access them? If I'm buying a house, I do not want my seller under any circumstances to be viewing all of our security footage right along with me. Yes, ma'am.
Good question.
Yes, ma'am.
You know, we have investors who got the keys and openers say they don't have all of those. Are they obligated if they don't have it in their possession to provide it?
If they don't have keys, that's a good question. If they don't have keys, how are they getting how is everybody getting access to the house?
No, I'm talking about like the openers and like pool pass. If they say they don't have it or it was lost, are they obligated to provide?
So they are, unless they disclose it. So what I would do on an offer is respond and add a special stip that says all parties acknowledge that the seller is an investor and has no knowledge of X, Y, and Z, and that the buyer is fully responsible for obtaining those things. So if you add it as a special stip, it would cover your seller. And then the buyer goes into it knowing that. Oh, are we done with this one? Sorry. I was like, oh, where did I leave off? Okay. Closing law firm. The buyer shall have the right to select the closing attorney to close this transaction. Let's read that again. Buyer shall have the right to select the closing attorney to close this transaction. How many sellers, and I say sellers loosely, counter offer with a specific closing attorney?
Many.
Many. At the end of the day, what do both parties have to agree? Yes. So if a seller says, I'm going to counter with this closing attorney, and the buyer doesn't accept, the seller can say, I'm just not going to accept your offer if it has this closing attorney on it. At the end of the day, if there is a valid reason for using that attorney, so for instance, if you're buying a HUD house, it is better to use one of their attorneys. Why? Because you're going to close faster, because they have already done all of the title work on these properties. So if this is a property where the closing attorney has already done work on it and a listing agent can verify that, yes, this is why we're asking for this closing attorney, then great. But I'm not a fan of listing agents choosing the attorney, because that's who it is. It's the seller could literally care less who closes it. So I'm not a fan of listing agents throwing away deals because they can't get the closing attorney that they want. Now, that being said, is there a reason to use specific lenders? Closing attorneys. Yes, sometimes. But I guess what I'm saying is get to the bottom of it, because at the end of the day, our contract says that our buyer has the right to choose. And sometimes you need to redirect the listing agent to that sentence. So highlight it and know where it's at. So buyer shall have the right to select the closing attorney to close this transaction, and hereby selects the closing attorney referenced herein. In all cases where an individual closing attorney is named in this agreement, but the closing attorney is employed by or an owner, shareholder, or member in a law firm, the law firm shall be deemed to be the closing attorney. So let's stop right there. If you put Rob Fricks on your contract, that means anybody in Frick's law firm can close the deal. If buyer's mortgage lender refuses to allow the closing attorney to close this transaction, the buyer shall select a different closing attorney acceptable to the mortgage lender. The closing attorney shall represent, you guys need to highlight this, the closing attorney shall represent the mortgage lender in any transaction where the buyer obtains mortgage financing. In transactions where the buyer does not obtain mortgage financing, the closing attorney shall represent the buyer. So highlight that. If it is a cash deal, the closing attorney is representing the buyer. In preparing the closing documents, attempting to clear title of the property to the satisfaction of the title insurance company, conduct the closing, dispersing funds according to the settlement statement signed by the parties and closing attorney, timely recording deeds and issuing an owner's title insurance policy. Other than those activities specifically listed above, nothing herein shall obligate the closing attorney to perform other legal services, including but not limited to certifying or warranting title of the property for the buyer, except pursuant to a separate engagement agreement signed by the closing attorney and the buyer. So that sounds like a whole lot, but this is basically what that means. If the buyer is paying cash and now the attorney is representing them, the attorney is still only obligated to do closing tasks. If the buyer wants something in addition to that, the buyer needs to hire the attorney for a fee with a written document that says that they are hiring them for a specific performance of whatever. Does that make sense? Holder of earnest money. The earnest money will be paid to holder in a method of payment acceptable to the holder. Holder has the right to charge the buyer for any cost associated with receiving earnest money. Such charge shall be collected separately from the payment of earnest money. The fact that holder may represent one of the parties in this transaction as a client or is working with such party as a customer is acknowledged by all parties and shall not be the basis for holder not performing any of its duties hereunder, including but not limited to dispersing the earnest money based upon a reasonable interpretation of this agreement. That means if my clients are the buyer and Maximum One is holding the earnest money, just because I represent them does not mean that they are getting the earnest money. I am still required to follow the contract and have a reasonable interpretation of the contract. The earnest money will be deposited into the holder's escrow trust account, with holder being permitted to retain the interest if the account is interest bearing, not later than 5 banking days after the binding agreement date hereunder, or 5 banking days after the date it is actually received, if it is received after the binding agreement date. If buyer writes a check or pays with an ACH for earnest money, it must be drawn upon an account in a financial institution located in the United States. When the same is deposited into the holder's escrow account, holder shall not return the earnest money until the check or ACH have cleared the account on which the check was written from, or from which the ACH was sent. So this is key to note. If your buyer gives me a check, a personal check, and then 3 days later terminates it, I'm still not dispersing the money. Even if I have a signed written agreement from the buyer and the seller, it's going to wait 10 days before I disperse that, because I'm not eating a return check. In the event any earnest money, so back to that, especially if your buyer is turning around and is purchasing another thing, like if things need to move quickly, you need to make sure that your buyers are getting certified funds instead of personal checks, if it's important that they get it back quickly. In the event any earnest money, check, or ACH is dishonored by the bank upon which it is drawn, or earnest money is not timely paid, we're going to come back to that, holder shall promptly give notice of the same to the buyer and seller. Buyer shall have, so this is the directions on what happens if a check is dishonored or not turned in the time frame that it's supposed to be turned in. The holder shall promptly give notice, and then the buyer shall have 3 banking days from the date of receiving the notice to cure the default. And if the buyer does not do so, the seller may, within 7 days thereafter, terminate this agreement upon notice to the buyer. If the seller fails to terminate the agreement timely, the seller's right to terminate based on the default shall be waived. So these have there are very specific instructions. There are days that you need to be counting, and if your seller is going to terminate, it is a very limited time that they have to terminate, so you need to make sure that you are aware of these time frames.
Now it says banking days, right? Didn't say that before.
It didn't, but then this one, seller may within 7 days, and that one does not say banking days, 7 days thereafter terminate this agreement upon notice to the buyer. If seller fails to terminate the agreement timely, the seller's right to terminate based on default is waived. In the event the holder's bank charges any fees related to buyer's check or ACH being dishonored, the buyer stopping payment or buyer's failure to deliver earnest money, holder shall notify the buyer, and the buyer shall immediately reimburse the holder of the cost of the fees in addition to fulfilling their earnest money obligations. So this is going to be key for you guys, and something that I try to reiterate all the time to agents. If you have a contract and the earnest money is due in 1 day, does your broker know that the earnest money is, if your broker is the holder, do they know that the earnest money is due in 1 day? They probably have not seen your contract. Is there somebody else who does accounting? Probably. So there's multiple people within an office. you are really the only one who knows, right? It may be sitting in compliance somewhere, but the person who needs to send the notice does not know that the earnest money has not been turned in. So it is your obligation to notify the holder, whether that's your holder or your broker, the other broker, the closing attorney. Is the closing attorney keeping track of your earnest money deadlines? No. You need to be calling the closing attorney and saying, hey, you have a contract, you are the holder. The buyer had 1 day or 2 days or 3 days, and now we're on day 4. I need a 10-day letter written. Whoever it is needs to be notified that they need to write the 10-day letter, because none of these time frames start until that 10-day letter is written. In representing your clients, make sure that the party who is holding the earnest money is told that they need to write a 10-day letter. I mean, not a 10-day, I keep saying a 10-day letter, that they need to write a notice that, whatever, the earnest money hasn't been. Now there's a form, which I love. So if you're a broker, fantastic news for us. Earnest money, entitlement to earnest money. So this is who's going to get what and when and how and under what circumstances. Subject to the paragraph below, the buyer shall be entitled to the earnest money upon failure of the parties to enter into a binding agreement. If it never goes binding, they don't have to turn in earnest money. If they've already turned it in and it doesn't go binding, it's theirs. 2, failure of any unexpired contingency or conditions in which the agreement is subject to. 3, termination of this agreement due to the default of the seller. 4, termination of this agreement in accordance with a specific right to terminate set forth in this agreement. Otherwise, the earnest money shall be applied towards the purchase price of the property at closing, or if funds are used to pay for the purchase price, then the earnest money shall be returned to the buyer. Disbursement of earnest money. Holder shall disperse the earnest money upon the closing of the property. 2, a subsequent written agreement by the buyer and seller. That means your termination, where both parties have signed the second portion of the termination, which is the disbursement of the earnest money. Both parties have to sign it. Or 3, an order of the court or arbitrator having jurisdiction over any dispute involving earnest money. Or 4, the failure of the parties to enter into a binding agreement where there is no dispute of formation or enforceability of this agreement. In addition, holder may disperse earnest money upon a reasonable interpretation of the agreement, provided that 1, the holder first gives parties at least 10 days notice stating to whom and why the disbursement will be made. So if the parties do not agree in writing, they don't both sign the bottom, guess what happens now? Now the holder has to write a 10-day letter and give all parties 10 days to give me any reason why. I'm going to tell you who is going to get the earnest money and why. And if you disagree with it, you have 10 days to notify me. And 2, no interpretation shall be made by the holder dividing the earnest money between the buyer and the seller. So if I say, look, you both are wrong, you both have done things against the contract and are in breach of contract, I can't split the money. You guys can agree to split it if you want, but I can't split it. And if I can't come to a very clear decision on it, it's going to court. If it goes to court, it's going to cost y'all, not you guys, but the buyer and seller, it's going to cost them some money. So sometimes it is much easier to get the parties to agree to just split it when they're both in the wrong. But no holder can do that without both of their written consent to do that.
Have you had any situations like that?
Yeah. Yeah, and they've both been in breach. And so for that reason, and I talked to them both personally, and so that's where whoever is holding the earnest money probably needs to be involved, because there's most of the time some tension between them, and they're angry and they're whatever. Let the broker, let the attorney get involved and talk to them directly. Usually we can reason with them, because who wants to go to court over $1,000 when a couple $100 is going out of it just to put it into the court? Somebody may lose attorney fees. So do you really want to risk a judge going against you and charging you their attorney fees? So anyhow, yes. Any party, real estate licensee, or I've already lost myself again. Any party, real estate licensee, or any other person having knowledge of or an interest in the disbursement of the earnest money may object to or provide information regarding the proposed disbursement by giving written notice of the same to holder within the above referenced notice period. That's the 10 days. Objections not timely made in writing shall be deemed waived. So let me give you a quick example of something that happened. We had a contract. We had a 10-day due diligence. Buyer terminated on day 9. These were the facts that I had in front of me. So I wrote a 10-day letter. Who did I give the money to? The buyer, because they were in their due diligence period. That's what I had in front of me. What I did not have in front of me was and the seller was refusing to sign it because the seller said, the buyer asked me to do like $3,000 worth of repairs, and I did them, and then they terminated. And he's like, I want my money back, blah, blah, blah. I want the earnest money. That's the least that they can do. And so they're bickering back and forth. And I'm like, well, she's in a due diligence period. I understand, but you should have waited until after the due diligence period. So I just wrote my letter, right? My 10-day, it's going to the buyer. And then I receive a copy of the signed amendment by both parties that said, which was them agreeing to that the seller was going to do the repairs and that the due diligence period was going to terminate on day 6. Oh, well, that changes things, right? And that's what that 10-day period is for, because I might not have all of the information that's super important to have when you're making the decision on who's getting the earnest money. So this gives you, the agent, or anybody else who has any sort of interest in it, the right to write the letter stating why you don't agree with it. Now, just because you write a letter, I haven't gotten a whole lot of letters, but the few that I have is not based on the contract. They're based on feelings. And I get them and I understand and I sympathize, but it doesn't change the contract. So.
One quick question. As a listed agent, will we advise our client do all the repairs after the?
Yes, definitely. Because when they're in a due diligence period, they can walk away because the sky looks a little too purple today. They don't have to have a reason. If it were me, I would actually wait until, depending on the repairs, but I would advise waiting until after the inspection, after the appraisal, because any reason that they can get out.
No painting until all of that.
Well, painting maybe.
I was like, painting.
Actually, they probably should have done that for you.
Well, and at the end of the day, I would only paint neutral colors anyhow.
Yeah.
If a buyer comes in and says, I want this house painted, seller agrees to paint it, and they're like, okay, I want this wall dark green, I want this one over here orange. If they don't end up buying the house, you're stuck with all of the colors that they picked out. So, Right. And that's the thing too. Like if it's a safety issue and you're like every buyer's going like
Have this,
it,
yeah.
you might as well go ahead and fix it. You probably should have fixed it before listing it, but now that it's come up, let's go ahead and get it done. But if it's something like they want hardwood floors put in instead of the carpet that's there, so no, we would not be doing that until that would be scheduled like right before closing when I know that everything is clear, they have a clear to close, whatever. Actually, I still wouldn't do it. I would do money instead, but I'm very big on money. Like money is so much easier.
I'll pay you to get it done.
Yeah.
And then they're not going to want to get done anymore.
Yeah. If holder receives an ejection or any other information and after considering it decides to disperse the money as originally proposed, the holder may do so and send notice to the parties of holder's actions. If the holder decides to modify the proposed disbursement, which I did that one time, I'll keep reading. Holder shall first send out a new 10-day notice to the parties. Now I had to reissue another 10-day letter that started the time frame over, saying I now have an amendment where due diligence period was ended on day 6, not on day 10, and thereby the buyer had no rights to terminate, blah, blah, blah. Notice to the parties stating the rationale for the modification and to whom the disbursement will now be made. Holder shall disperse the earnest money to the seller by check in the event that the holder makes a reasonable interpretation of the agreement that the agreement has been terminated due to the buyer's default, and 2, sends the required 10-day notice of the proposed disbursement to the buyer and seller. The above referenced check shall constitute liquidated damages in full settlement of all claims of the seller against the buyer and the brokers in this transaction. Holder may require the seller to sign a W-9 before issuing a check to the seller for liquidated damages of $600 or more. If I am taking somebody else's money, the buyer's, and giving it to a seller that is more than $600, which most earnest money is, whoever is holding it is going to require that the seller fill that out, because guess who wants their tax money? Because now that is income to a seller. They have benefited by probably thousands of dollars, and the IRS wants their tax money on it. Such liquidated damages are a reasonable pre-estimate of the seller's actual damages, which damages the parties agree are difficult to ascertain and are not a penalty. So just a quick side note, when somebody has a $1,000 earnest money and they're wanting to extend it to 60 days instead of, like they want a longer closing, blah, blah, blah. At the end of the day, you need to remember that your seller cannot get anything more than what the earnest money is. So if they're asking for long time frames, if they're asking for a lot of stuff, you're probably going to want to do what to the earnest money? You're going to want more, because that is the seller's only remedy, period, is the earnest money. Buyers have a couple of things that they can do, including suing for specific performance, but a seller cannot sue a buyer for specific performance. Only a buyer selling a seller. A buyer suing a seller. Interpleader. If an earnest money dispute cannot be resolved after a reasonable time, the holder may interplead the earnest money into a court of competent jurisdiction if the holder is unsure who is entitled to the earnest money. The holder shall be reimbursed and may deduct its costs, expenses, and reasonable attorney fees from any funds interpleaded. The prevailing defendant in the interpleader lawsuit shall be entitled to collect its attorney fees, court costs, and the amount deducted by the holder to cover the holder's costs and expenses from the non-prevailing defendant. So that's what you need to show your clients when they're like, no, I'll just go to court over the $500. You might want to rethink that because if it doesn't go in their favor, it's going to cost them a lot of money. It's going to cost them my attorney fees and the other party's attorney fees, along with the court costs, which are a couple $100 to interplead it. Like, you're looking at some money, right? So sometimes we need to make sure that our clients are making
Good decision.
business decisions and not emotional decisions. Hold harmless. All parties hereby covenant and agree to indemnify and hold holder harmless from and against all claims, injuries, suits, and damages, collectively claims, arising out of the performance by the holder of its duties, including claims caused in whole or in part by the negligence of the holder. 2, not sue the holder for any decision of holder to disperse earnest money in accordance with this agreement. Inspection and due diligence. The buyer's right to inspect the property. Unless otherwise specified herein, the property is being sold in as-is condition with any and all faults. Therefore, buyer and buyer's representative shall have the right to carefully inspect the property to make sure that it meets the needs of the buyer. If the buyer is concerned that the property may have been used as a laboratory for the production of methamphetamine or as a dump site for the same, the buyer should review the National Clandestine Laboratory Register, Georgia, at www.dea.gov. The buyer's responsibility to inspect neighborhood. Notice that it says responsibility. In every neighborhood, there are conditions which different buyers may find objectionable. Buyer is solely responsible for becoming familiar with the neighborhood conditions that would affect the property, such as landfills, quarries, power lines, airports, cemeteries, prisons, stadiums, odor and noise producing activities, crime, school zoning, and land use, and government and transportation maps and plans. If the buyer is concerned about the possibility of a registered sex offender residing in the neighborhood in which a buyer is interested, the buyer should review the Georgia Violent Sex Offender Registry available on the Georgia Bureau Investigation website, which is provided there. Neither seller nor seller's broker shall have any duty to disclose information about sex offenders in the neighborhood. On a side note, if you are the buyer's agent, do not put yourself in a position where you are looking at sex offender registries, zoning maps. Let that guide them to the place that they need to go to check school zones. But guess what happens to school zones?
They change daily.
All the time. So do you think that this has happened? My agent told me that I was zoned for HOCO. I bought the house and it's not zoned for HOCO. Now it's zoned for Perry. Has that happened?
Yeah.
Yep. Guess what can't happen if they're the ones doing it? They can't blame you if they're the ones doing it. So those need to be things that you are letting them know, especially, which most buyers do, are looking in school zones. You need to let them know that school zones, even though the website, we can verify, I can show you where you can verify that this is zoned for this right now. But if you want to know what it's going to be zoned for next year, you need to do your own due diligence on that. They need to go do some digging, make some phone calls, but don't put yourself in that position, because if it turns out differently, you've put yourself in a position to be able to be sued for it because you are trying to help them. Does that make sense? Buyer's inspection rights continue through closing. Upon prior notice to the seller, the buyer and/or buyer's representatives shall have the continuing right through closing to enter the property at buyer's expense and at reasonable times, and among other things, and without limitation, conduct inspections and examinations, evaluations, appraisals, surveys, and tests, meet contractors and vendors, measure for renovations, determine the condition of the property, and confirm that any agreed upon repairs have been made. The seller shall cause all utilities, systems, and equipment. You guys need to highlight this. Seller shall cause all utilities, systems, and equipment to be on and all parts of the house to be accessible, including basements, attics, and crawl spaces, so that the buyer may complete all inspections. Some sellers do not think that they have to keep their utilities on because they've moved down to Florida already. Utilities must stay on through closing, not just through their due diligence period. Can a buyer who had 5 days due diligence, and we're now on day 15, are they allowed to do a home inspection on the house? Yes. They can absolutely do a home inspection. Can they terminate based on the home inspection? No. But they can absolutely do it. And what would happen if they walk away?
Lose their money.
That's all that's going to happen. They're just going to lose their earnest money. But if they're like, that roof is looking kind of rickety, and then they have somebody come out and find out that the whole roof needs to be replaced, and the seller's like, I'm not replacing nothing. Can the buyer walk away? They can. Like they're gonna owe now, and I say this, but would they owe commissions? So your buyers need to be aware of that too, that it's not, that's all that the seller can collect is the earnest money. They can't sue them and make them close with it. But now you're probably not going to sue them. You're going to help them find another house and you'll make your commission off of that. But could the listing agent sue them? They could. Would they? I don't know. Would they win? I don't know. But your buyer would need to know that when making that decision. Buyer's inspection, indemnification obligations. Buyer agrees to hold the seller and all brokers harmless from all claims, injuries, and damages related to the exercise of the above inspection rights by the buyer and buyer's representatives, and buyer shall promptly pay the seller for actual costs to restore any portion of the property damaged or disturbed from the testing or other evaluations to a condition equal to or better than the condition it was prior to such testing or evaluations. Notwithstanding the above, this indemnification obligation shall not apply to damage resulting from defects in the property uncovered during the inspection of the property. So if something was already wrong with it, the buyer is not going to be required to repair it because it was already damaged. So here's something that has happened. Buyer wanted to have a septic inspection, and when they had the septic inspection, he's like, we really should look at, a couple of things, and they started digging up the yard. Was the buyer allowed to do that?
Yeah.
Yes, they were. Now they have to put it back. And if they've dug out and they have this big brown, trail of whatever, of dirt, now they're going to have to sod it. They're going to have to put it back to, or pay what it would cost to put it back to what it was. But the buyer can, and a seller was not happy, but they did have the right to do it. And luckily they ended up closing on the property, but they can do it. Due diligence period. If the property is being sold subject to a due diligence period, then A, this agreement shall be an option contract during which time the buyer shall have the option for any reason or no reason to terminate this agreement upon notice to the seller given prior to the expiration of the due diligence period, in which case the buyer shall be entitled to a return of the buyer's earnest money without penalty. B, buyer may, during the due diligence period, seek to amend this agreement to address any concerns buyer has with the property or this agreement, and C, if the buyer has not terminated this agreement as set forth above, The buyer shall accept the property and as is conditioned, subject to an amendment to this agreement to address concerns agreed to by the parties. So, let me give you an example of some things that go wrong. You're in a due diligence period. You have 10 days. You're on day 10. You put together your buyer's requests for the seller to fix. She's like, I'm not buying this property unless they do 1, 2, 3, and 4. Send it over to the seller, and you have no response. And it is 7 p.m., and then it is 9 p.m., and then it is 11 p.m. What happens at 12 o'clock?
Their time runs out.
Their time runs out and they are no longer in their due diligence period. Does the seller have to fix anything? No. How do you protect your buyer when the seller is not responding?
You withdraw contract or extend the due diligence.
Well, if you extended it, what would you need? You would need the seller's signature. So that's not going to work because the seller's just not responding.
Termination of the contract.
You can terminate. And then there's one other option, and there's a special step, which I probably should have printed out for you guys, but it is a GAR special step that says, in essence, I am summing it up, but go look up the GAR special step. Please do not write your own special steps. It gets more agents in trouble than I think anything else is writing your own special steps. But there is a special step that says, in the event that the seller and buyer do not come to these terms of agreement as set forth above, then this is serving as the notice to terminate. So what that does is you send that over prior to 11:59. And if the next day the seller says, yeah, I'll accept this and signs it, you're good to go and you keep going on. But if he says, nope, not doing this, the seller or the buyer has already given their notice to terminate. So now you just have to follow through with the termination within the due diligence period. So that notice was given prior to 11:59. So you've already given the notice within the due diligence period. They will get their earnest money back. Here's the caveat. If they don't come to terms, and then your buyer says, because the buyer asked for a new roof and a new fence and the kitchen sink to be fixed, and the seller says, I was already getting the roof replaced, but I'm not fixing anything else. And then the buyer sends over that notice that here's your notice that it's going to terminate. And then he doesn't agree to everything, so he's not going to sign that, right? And then the buyer's like, I still want the house. It's already terminated. You've already given your notice that if this isn't signed, that it's going to terminate. Now the seller gets another offer. And he likes that offer. It's a little bit more than yours. So, things to think about. Be careful and make sure that when you put that notice in there, that your buyer understands that you're risking losing it. And if they're like, look, if they're not I only asked for one thing, and if they're not willing to do it, I'm willing to walk away. I want to walk away. Then you're good. Then put that in there. Does that make sense? But sometimes just make sure that they understand the full aspect of what happens with it. Seller's duty to disclose. The seller shall disclose to buyer any and all known latent or hidden defects in the property that could not be discovered by the buyer during a reasonably careful inspection of the property. So let's talk about this for one quick minute. A kitchen sink is leaking under the cabinet. Does the seller have to are seller's disclosures required in Georgia? No, they are not required. Latent defects are required, and there is a latent defect disclosure. Are they required to sign that?
Oh, wait, yeah.
Only if there are latent defects to disclose. If there are no latent defects, do they have to sign something that says there are no known latent defects? No, but it is a good idea to disclose that no, there are no hidden defects. So here's the scenario. What is a latent defect? Do they have to disclose that there is a leak under the sink in the kitchen behind the the cabinet doors are closed and it's leaking and it's leaked all underneath it, but the cabinet doors are closed? Does the seller have to disclose that the kitchen sink is leaking?
No, you should be able to see it. No, they should. Or test it. You're supposed to
If
run
they
the
know
water.
that
test
they
it.
know
Disclosure.
that it's leaking,
They
You can
should.
see it though.
if they know.
I don't
that-
know anymore.
So
They should, but they don't
So-
have to.
Yeah, they should.
that you are correct.
They should.
So if it can be found in a home inspection, it does not need to be disclosed. Yes, so a leak under the kitchen sink would be found during a home inspection. So it does not have to be, it is not required to be. Should it be? Like, I would recommend that they do.
I would recommend fixing it.
Because exactly, I mean, at that point, literally,
If you're
you're
gonna sell the
damaging your own property. So, yes, fix it. Actually, I wouldn't. Okay, so here's another scenario. The upstairs laundry room, which is above the kitchen, has leaked, and it has left a water ring, but they fixed the leak. It was actually like a drainage issue. They cleared the pipe. It was fixed. There is no drainage issue now. Do they have to disclose it?
Yes.
No, because they fixed it.
Correct. No, because it is no longer a defect. And
But,
you could see
but somebody
this.
is gonna ask.
But if
Somebody
the-
will ask.
But if the buyer asks, would they have to disclose it?
They could say, it depends. What if they're an investor? They really have no knowledge. Like, they just know that they had it checked out and it was fixed. Like, and that happens a lot with investors. So there's one made specifically that says, I've never lived in this house. I don't know anything about it.
Don't care to know.
Yep. So what would be a latent defect that they would be required to share?
Water damage or mold or something.
So anything that could not be found in a home inspection, which kind of like, well, what couldn't it? And I say home inspection, but there is a whole long, very tiny printed, so it is a lot of stuff in there, types of inspections that they are advised to get. But here's a scenario that has happened. The upstairs laundry did leak. They fixed it, and they fixed the tiles, and they didn't disclose it. Were they required to disclose it? Not really, because it was no longer a defect, right?
Except for the mold.
Except for the mold that went underneath and up and inside their walls. And so when the buyer purchased the property who did not know about the leak, opens up the wall and finds mold in there because it wasn't dried properly. So that is a latent defect. Now, the seller didn't technically know about it, so that went to court. Because how do you disclose something that you didn't know about? But should he have disclosed the water, because it could have put them on notice for something that created a latent defect that nobody could find. So there's arguments to be made. My advice, over disclosure is always better than under disclosure. But I've had sellers say, am I required by law to disclose that this happened? I had it fixed. Here are the receipts. And my answer was, you are not required, but why wouldn't you? Just kind of, ask yourself that. You literally have the receipt sitting in front of you where it was fixed. Why wouldn't you just disclose it? In case something comes up, now you've put them on notice. Now that's on them. Yes, ma'am.
I wanted to ask, like, say for instance, a seller, you're representing a seller seller and they had an offer come in and a buyer does the inspection or whatever, and you find a latent defect such as mold and things of that nature. If that current buyer does not purchase the property, do you have to, is that now since you know from the inspection report,
Well,
do you?
So if it was found on an inspection report, is it latent?
No. No, but it has to be disclosed, right?
Well, it could be found though.
Right. But doesn't it have to be, I mean, anything that's found on an inspection report before you don't have to disclose what's found on it?
No, an inspection report could tell me that I have a leak under the sink and I don't have to disclose that because the next buyer can find it in an inspection. Now, I'm not saying that I agree with all of these laws. I'm just telling you what the laws are as they are. So here is something else to note that your buyers should be fully aware of. And I say buyers, really your sellers too. What does it take to become a home inspector in Georgia?
Lots of hours.
Certification.
The certification.
They don't have to be like.
Oh, yeah.
Correct.
Yeah, let's be licensed.
0. You have to pay your $120 online to the state of Georgia to create your business and order your business cards or print them off of your printer, and you are now a home inspector.
I thought they had to have.
Inspector with Lynn Home Inspection.
So scary.
And he has gone through a ton of schooling.
Now, is there schooling available? Yes. Is there certifications that are available? Yes. Do all home inspectors do them? Absolutely not. And I would say a big majority of them have no education in like, and I say education, I mean like classes, courses, certifications. There is none. And literally the requirement, they are not licensed like we are licensed. And these are the same people who are advising your buyers of what is wrong with their home. Now, that is enough. That is something that there are many things that I will say about the state of Georgia. We have the best contracts. We are so strict. We are like Florida brokers don't want anything to do with Georgia because Georgia is so much harder and harsher and our laws are we cover everything. This is the one place, I don't know why, but it is not covered. They are not licensed. There is nobody overlooking home inspectors whatsoever. So do your buyers need to know that? Yes. You need to find a home inspector who does have some certifications, who has lots of things behind them, like warranties. Like they're going to put a 90-day warranty on it. And if I say your dishwasher is working and it stops working in the next 90 days, I'm going to cover it myself through the home warranty company that I work through. So there are things like that. Your buyers, they're the ones who are going to make the decision. But how many people are like, oh yeah, my dad does construction and so he's going to come look at the house?
That's on you.
It is. And in those instances, I strongly recommend, we have a service recommendation form that our agents have full access to. They're not required to use it, but it is highly, highly, highly advised to use it. If you guys want a copy of it, you're welcome to rip it off and repeat. It literally says, and it lists everything from I do or do not want a termite inspection. I want a home inspection. I want a radon inspection. And it goes through a laundry list of things. And then there's a place where you can add extra things. But they literally have to initial next to each and every one of them, yes or no. Because as a broker, what do I get? I get the problems, right? What are some of the biggest problems? That right there. After they close, something happens with the house and it's either the agent's fault or the inspector's fault, right? So those are like the biggest issues that as a broker I see. Anyhow, I don't know how we got so sidetracked off of our contract. But I know. Yes, expanding. I like that a lot. But make sure that your buyers are fully aware when they are hiring home inspectors.
And we can give recommendations.
Not everyone's equal.
Yes, not everybody is equal. And that's equally important for your sellers. When you get this laundry list of a thing, I literally had to go save one of my agents' contracts. So here's what happened. Another sad story, sorry. So she calls me and she says, Tracy, I've listed a house. We're under contract. And now I've taken off and I'm on vacation with my husband. We just got back this inspection report, and it says on the inspection report that the roof has to be replaced. So my sellers are freaking out. The buyers are walking away, but this house is only like 10 years old. The whole house, not even just the roof. The whole house is like 10 years old. And I'm like, well, that doesn't make a lot of sense. So I get in my car, I drive over there, and I'm looking at this roof, and I'm like, there's absolutely no way. Like, what? And am I a roof inspector? Mm-mm. So what did I do? I picked up the phone, I called a roofer, and I said, I need you to come inspect this house for me, like today, because these buyers are walking. He came out to the property and he said, Tracy, I make a living off of replacing roofs. And as a side hustle, as a smaller amount, I repair roofs. And I can't find even the slightest repair on this roof, let alone replacement. And I said, please tell me you will put that in writing. And he was like, absolutely. So saved the deal, got the buyer the information. The buyer was like, what? Like, it doesn't have to be replaced? I'm like, no, absolutely not. So then the buyer says, I'm going to hire another roof inspector. I'm like, have at it. But I say all of that to say, this all started from a home inspector who has, no training, definitely not a roofer, who put on a report to a buyer that their roof had to be replaced.
Who didn't even look at the roof, obviously.
Like, what?
No, that's a good inspector that says that.
So that you will see on like 97% of inspections. Yes, ma'am.
Quick question.
Mm-hmm.
We get sometimes some buyer's agent get mad and send a whole inspection report, and then we're told that now your seller has to disclose all of this. In that example,
Nope. Absolutely not.
See, that's
One,
always
yeah, no. One, if it was found on an inspection report, it doesn't have to be disclosed anyhow at all. What has to be disclosed are latent defects. Now, I can't lie about it, but here's another quick scenario. So hopefully we can get to the end of this. But I feel like the scenarios are what really teach you guys and that like stay with you. There was a buyer who was looking at a home. They went downstairs into the basement area, and the buyer's agent, who thought she was looking out for her buyer's best interest, says, there's some mold right there. And the buyer freaks out and says, my child's allergic to mold. Let's get out of this house. They leave, don't write an offer. They had loved the house up until that point, had talked all the way through the house about writing an offer on this house. So seller reviews the footage in his house and is like, I don't think that's mold. So he calls a mold remediation company who comes out and says, that's not mold. Sued the buyer's agent, the seller sued the buyer's agent because the buyer's agent gave knowledge that it was mold when it wasn't mold and took away a client, a buyer. So I say that to say, a couple of things. One, do not put yourself in a position that you are telling them what is wrong with the house, because you guys are not home inspectors, not that you'd have to be licensed anyhow. Can you tell that I don't agree with this? But like, you're not a mold remediation place. You're not, like, you don't have any special training in that. So don't try to be helpful by providing information that could later turn out to be wrong. And remember, and always, always remember that you're probably on camera no matter where you're at. And tell your clients before they go in the house. And that's how he knew, was because there were cameras all over, and that was part of their case, was like they were getting ready to write an offer on this. And this buyer now left because the agent told her that it was mold and our kid's allergic to mold, and it wasn't mold. So I lost out on a deal. Yeah, it turned into a whole huge thing. But be careful. I don't even know where we're at on the contract now. Where are we?
We're on let this thing.
Okay, number 9 on page 4. Okay, that makes me feel a little bit better. Any portion of a residential dwelling on the property if any portion of a residential, remember that, residential, so this is not land, dwelling on a property was built prior to 1978, the lead-based paint exhibit F316 is hereby attached as an exhibit to this agreement. The term residential dwelling includes any painted fixture or material used therein that was built or manufactured prior to 78. Buyers shall have the right to conduct a lead hazard evaluation within 10 days from the binding agreement date, or other mutually agreed upon time period, and to terminate this agreement without penalty upon notice to the seller if lead-based paint and or lead hazards are found, unless these rights are waived by the buyer in the lead-based paint exhibit. Guys, if you are representing a buyer, do not let them waive their 10-day right, even if they don't go and look at it. I do not want to stand in front of a judge and ask a judge why my buyer would give up the 10-day right that they have, only to later find out that there was lead-based paint, and now they've caused all of these issues. Why did you not give them the 10 days? Like, it's written all over. The other thing I'm going to say and note about lead-based paint, because you cannot be writing an offer on a property without the lead-based paint disclosure in your hand. Your buyer has to sign it before you write the offer, before you submit the offer. The worst thing that you could do is fill out the seller's disclosure on lead-based paint and have your buyer sign it and send it to the seller to finish signing. Like, no, never, ever, ever do that. Always have the parties fill out their own portions, and never have a buyer sign a document that the seller hasn't already filled out. Does that make sense? Brokerage relationships and compensation in this transaction. No broker in this transaction shall owe a fiduciary duty or any other duty to buyer or seller greater than what is set forth in their brokerage engagements and brokerage relationships in real estate transactions. No agency relationship. Buyer and seller acknowledge that if they are represented by brokers in a client relationship, they are each solely responsible for protecting their own interest, and that broker's role is limited to performing ministerial acts for that party. And B, if the same brokerage firm is representing one party that is a client and working with the other as a customer, the broker and all the broker's affiliated licensees are representing the client. Consent to dual agency. If broker is acting as a dual agent in this transaction, the buyer and seller shall consent to the same and acknowledge having been advised of the following. I'm not going to read the dual agency disclosure because it is legal in Georgia, but most brokerages won't allow it. We'll just skip down to number 2, designated agency. If broker in this transaction is acting in a designated agency capacity where one or more licensees of brokers are exclusively representing the buyer and one or more of the licensees of broker are exclusively representing the seller, the buyer and seller consent to the same and acknowledge that each designated agent or agent shall exclusively represent the party to whom each has been assigned as a client. How are we on time? 11, 12. Oh, it's break time. And then we will pick back up at compensation because that's always got a lot of questions.
Tracy, what's this course number? The name?
Where's the sign-in sheet? So,
It's Contract Bootcamp.
well, it's the actual class name. Here's the GREC license or the GREC number, 61551 on here. Is that what's on there? Yeah. Here's the sign-in sheet.
Dissection.
Well,
It's a lot.
this is a contract class that we are making work into what I needed it to be. Yes.
So are there 5? Because I only saw 2.
There should be more added on there. We're on the 3rd one.
Oh, this is the 3rd one.
Yeah, so we did the buyer brokerage first. We did the listing agreement second, and then I think there was a holiday. And then this week is the purchase and sale. Next week will be the financing. So we go through all of the financing stuff, a couple of contingencies like the house, and then we get into exhibits. And then I think there's actually, I don't know, 6 or 7. And then the final one will be you get blank forms and I give you different scenarios and you're filling out a purchase and sale. We're doing counter offers. We're talking about negotiations and just things like that. So you're actually physically filling out based on different scenarios.
Okay.
So we
missed 3 classes.
well, once I finish it, I take usually like a week or 2 where I don't teach any, and then I start it all over again. We're just like on repeat because there's always agents who need it. And then I get the agents who are like, I missed this one, I couldn't come to it. But we are recording them as well, so that'll be good.
Well, I wanted to go to all of them. Didn't you want to go to all of them?
Yeah.
Okay. Well, and I didn't get your email.
What
I
email?
usually get emails that say that you're having classes.
Yeah.
Oh,
John said she got an email, and I didn't get one this time.
let's check.
I got like a stepchild.
I promise everybody is in constant contact. Did you check your spam?
I mean, you usually come right through to mine, but anyway.
Right. We can check the constant contact and see how they went because I didn't actually send out the emails. Janera did, and she does it through constant contact. Now, are you only part of one MLS? Are you? What about? Are you part Georgia?
And Central.
I don't have Georgia on there. I have Central Georgia, Middle Georgia in my constant contact.
But we're in Central.
So I'll have to check. But you have like a 15-minute break, and then we'll jump back in. So we're going to go ahead and get started again. We still got quite a bit to cover. I think we got like an hour left. So, boy. So we may breeze through some of it. Compensation of brokers. Buyer and seller shall be obligated to pay their respective compensation obligations, if any, to brokers in full at closing as a precondition to closing. That means they are not allowed to, they cannot close without paying your compensation. If they say, I'm not paying your compensation, they aren't closing. It is a precondition to closing. so long as the same is permitted by buyer's mortgage lender. The closing attorney is hereby authorized and directed to show the compensation of the respective brokers on a settlement statement at closing, and 2, disperse such compensation to brokers upon the consummation of closing pursuant to the agreement or agreements of party paying and receiving such compensation. The acceptance by the broker or brokers of partial compensation at closing shall not relieve the party owing the same from paying the remainder after closing, unless the broker or brokers have expressly agreed in writing to accept the amount paid in full satisfaction of broker's compensation. Remember that your compensation is paid through your broker based upon your sign-on package, that you signed with your broker. All compensation is always owed to the broker, so you cannot waive and accept partial payments. Only the broker can do that. So you need to check with your broker. Some brokers already have a pre-authorization. Like us, we don't care what you accept. We do not tell you that you can or can't work for a certain amount, or you can or can't rebate a portion of your commission. I don't advise doing it, but if you want to, you can absolutely do it. So if you're with Maximum One, that authorization is already in the paperless pipeline, already signed. All you have to do is print it out and put in the buyer's information. Like if you're doing like $1,000 rebate, you just put that in there. Disclaimer, buyer and seller have not relied upon any promises, statements, or representations, collectively representations of brokers other than what is included in this agreement in an amendment thereto or in a pre-showing compensation agreement. That means everything that has any standing is in writing, is attached to this agreement, is an amendment to the agreement, or is the pre-showing authorization. This shall include representations made after this agreement is entered into that have not been made as an amendment hereto and agreed to by all parties. Brokers shall have no duty to determine whether the identities of the buyer or sellers are legitimate in, where am I at? Sorry. Or inspect the property for termites, defects, hazardous conditions, and/or repairs. The brokers herein shall have no duty to advise the buyer or seller on any matter relating to the property which could have been revealed if the buyer had obtained with respect to the property. Now, here we go. This is the list of things that we are advising the buyer to get. A survey, appraisal, title search, official Georgia wood infestation report, utility bill review, septic system inspection, well water test, or a survey, appraisal, title search, official didn't they already say that one? Official Georgia wood infestation. Wait a minute. I'm rereading the same thing. Sorry. Well test or a test for radon, asbestos, mold, moisture, methamphetamine, and or lead-based paint. I really need my reading glasses. B, had the property been inspected by a professional construction expert or structural, soils or environmental engineer. C, had this agreement and transaction reviewed by an attorney, financial planner, mortgage consultant, or tax consultant, and or D, consulted appropriate governmental officials, maps, laws, and regulations to determine, among other things and without limitation, the zoning of the property, the propensity of the property to flood, flood zone certifications, and whether any condemnation action is pending and or has been filed or other nearby governmental improvements are planned. That's a lot of stuff for your buyer that they should be having, right? That we're putting on them, saying you are put on notice. Buyer and seller acknowledge that the broker do not perform or have expertise in any of these matters handled by the professionals referenced above or in the above test, inspections, evaluations, and reviews. Buyer and seller should seek independent expert advice regarding the above matters and any other matter of concern to them relative to the property and this agreement. Buyer and seller acknowledge that the broker shall not be responsible to monitor, supervise, inspect, or I don't know what that's supposed to be, on whether the construction of the repairs to the property were done properly, and that such tasks clearly fall outside the scope of real estate brokerage services. Buyer and seller fully acknowledge that brokers have no duty to ensure that seller has terminated sellers and or third parties' administrative access to devices. So this is putting all of the buyers on notice that these are the people that they should be consulting. Now, I caution you, do not step into, because when you start acting like a home inspector, a judge can mark through any part of this contract and make the rest of it still valid. And when you start advising them of things that you should not be, they're going to say that you are acting in that designation, and they're going to end up holding you responsible for it. So do not act like a home inspector. Advise them to have a home inspector, a roof inspector, whoever their questions are. When they're talking about taxes, what are the tax ramifications of blah, blah, blah. You are not a tax consultant. Do not get into it unless they are hiring you separately as a service that, you work for the IRS and you know all of the tax codes. Don't step into those roles because you're going to end up putting yourself in the lane of liability that you do not want to be in. Time limit of offer. The time limit of the offer shall be the date and time referenced herein when the offer expires, unless prior to the date and time both of the following have occurred. The offer has been accepted by the party to whom the offer was made, and B, notice of the acceptance of the offer has been delivered to the party who made the offer. Delivery is key. It is not binding until the delivery is sent to and received. And I say received, it has to be in their inbox, not that they have to open it. But here's another thing to note. On your purchase and sale agreement on the last page where it has all of your information on there, on your listing agreement or your buyer brokerage agreement, whichever side you are representing, you have all of your information on there, and that document authorizes you to accept notice for your client. So when notice is sent to you, it is deemed that the notice is to your client as well at the same time. Now, here's something that has happened. So be careful with this. The email address that was on the purchase and sale agreement was, let's just say, blah, blah, blah at max1platinum.com. Two agents, different brokerages, they went back and forth, and like myself, I have multiple emails. So let's just say this one was Tracy. It wasn't, but Tracy at max1platinum.com is what is on my contract. It is what is on my listing agreement. But because I have a relationship, a friendship with the other agent, they have my Gmail account as well. And then the notice, everything is going through my Max One Platinum, but when they send me notice, it goes to my Gmail account. Is that notice? Nope. So be careful when you are sending notices that it is to only the email that is on your purchase and sale agreement. That is the only place that is authorized and deemed as notice. Because if you're sending a termination and it's gone to the wrong address, that's another thing. You need to be double and triple checking when you're sending terminations that you didn't mistype the email, because if they don't receive it because you sent it to the wrong email, and then you go to show and prove that you sent it, and they're like, that's not my email. And now your client just lost their earnest money because of it. Their $2,500, where are they going to get that money from?
You.
These are lessons I want you to learn in here and not out there. Where are we at?
Other terms and conditions.
Did we already do the generally?
No.
Okay.
Start.
All notices given hereunder shall be in writing, legible, and signed by all parties giving notice. In the event of a dispute regarding notice, the burden shall be on the party giving notice to prove delivery. That means you're going to have to prove that you sent it to their email that is on here. The requirement of this notice paragraph shall apply even prior to this agreement becoming binding. Notices shall only be delivered in person, by courier, overnight delivery service, or by certified or registered U.S. mail, hereinafter collectively delivery service, or by email or facsimile. The person delivering or sending the written notice signed to the party may be someone other than that party. Delivery of notice. A notice to a party shall be deemed to have been delivered and received upon the earliest of the following occur. 1, the actual receipt of the written notice by the party. 2, in the case of delivery by a delivery service, when the written notice is delivered to the address of the party set forth herein, or subsequently provided by the party following the notice provisions herein, provided that a record of the delivery is created. 3, in the case of delivery electronically, on the date and time the written notice is electronically sent to an email address or facsimile number of the party set forth herein, or subsequently provided by the party following the notice provisions herein, even if it has not been opened by the recipient. You guys, another side note, be careful when you're taking vacations. If you're on a cruise and you are not going to have or could possibly have interrupted service, you need to have somebody back here who's taking care of your files, and at a minimum, your broker needs to be notified so that the one thing you do not want to do, what does GREC, what is the purpose of GREC? The Georgia Real Estate Commission. Their one sole purpose is to protect the public. That needs to be your number one job as well. If something happens to you when you're on vacation, your client still has to be taken care of. And that's another quick side note, make sure that when your contracts are signed, they're uploaded into whatever portal your broker uses. Because if you have a contract sitting on your desk and then you get in the car and you drive to the supermarket and you are in a car accident, I have no idea who that person is, right? Unless you've uploaded it into whatever portal that you guys have, that your broker has access to. So, when broker is authorized to accept notice for a client, except where a broker is acting in dual agency capacity, the broker representing the party in a client relationship shall be the authorized agent for the party for the limited purpose of receiving notice, and such notice to any of them shall for all purposes herein be deemed to be notice to the party. Notice to an authorized agent shall only be effective if the written notice is sent to the address, facsimile number, or email address of the authorized agent set forth herein, or subsequently provided by the authorized agent following the notice provisions herein, whether or not it is opened by the recipient, except as provided for herein. The broker staff at the physical address set forth herein of the broker are authorized to receive notices delivered by a delivery service. The broker and the broker staff shall not be authorized to receive notice on behalf of a party in a transaction in which the brokerage engagement has not been entered into with a party, or in which the broker is acting in a dual agency capacity. In the event that the broker is practicing designated agency, only the designated agents of the client shall be authorized agents of the client for the purposes of receiving notice. So the broker can receive notice on behalf of you, but except for when it's designated, it needs to be the specific agent. Default. Yay, the fun stuff. This is important when you are, whether you're representing the buyer or the seller, that they understand the terms of default before they sign this. Not when they're in the midst of, I'm walking away from this contract, I'm tired of the buyers, they're rude, they're, whatever. And then you have to go, oh, wait, by the way, go look at this part in your contract. Have that conversation up front. And that'll eliminate, and even if it doesn't eliminate, it makes those conversations much easier. So remedies of the seller. In the event this agreement fails to close due to the default of buyer, the seller's sole remedy shall be to retain the earnest money as full liquidated damages. Your sellers need to know that they cannot sue the buyer for anything other than, if they default on the contract, other than getting the earnest money. That is their only remedy. Seller expressly waives any right to assert a claim for specific performance. It specifically says they cannot sue a buyer and make them purchase the house. The parties expressly agree that the earnest money is a reasonable pre-estimate of the seller's actual damages, which damages the parties agree are difficult to ascertain. The parties expressly intend for the earnest money to serve as liquidated damages and not as a penalty. Unless the seller has otherwise waived the seller's right to terminate due to the buyer's failure to pay earnest money, the seller may, after the termination of this agreement, sue buyer for any portion of the earnest money that was either not paid, returned for insufficient funds, or the payment of which was stopped. Your buyers need to know that their earnest money, and I've seen this so many times, buyer has 1 day due diligence, 2 day due diligence, let's even say 3 day due diligence. They had 3 days in their contract to turn in the earnest money. And day 4 rolls around, the earnest money was never turned in. And on day 4 of their 3 day due diligence, they decide to terminate. And the buyer's agent says, you don't have to worry about it because you never turned in your earnest money. Wrong? Absolutely not. The buyer now owes it to the seller. And the seller can absolutely sue for it. And they will win. So be careful with that. Remedies for the buyer. In the event this agreement fails to close due to the default of the seller, the buyer may either seek for specific performance of this agreement, that would be taking them to court. What that does, this has happened, seller gets an offer that's better than this offer, and he says, I'm not selling it to this buyer. I've got a better offer. I'm taking it. That's it. I haven't sold it. You don't see my signature selling the actual house. I'm not. I'm terminating this agreement. Here's my termination. No, that's not going to work because the buyer is going to sue you for specific performance. And while the court case is going on, whether it takes 6 months or a year, there's going to be something on your title and the closing attorney is not going to be able to close on your house. So no, you can't just, hope that they go away. And no, that's not going to work. They can sue for specific performance and it will stop you from selling your home to the other person. 2, they can terminate this agreement upon notice to the seller and holder, in which case, seek specific performance of this agreement. 2, terminate this agreement upon notice to the seller and holder. in which case all earnest money deposits and other payments the buyer has paid towards the purchase of the property shall be returned to the buyer following the procedure set forth elsewhere herein, and buyer may pursue any other remedy available at law. So that part was added to, it's not just specific performance and earnest money, but any other remedies allowed by law. Okay, rights of the broker. The brokers involved in this transaction shall be express third-party beneficiaries of this agreement, shall have the right to enforce all provisions of this agreement that benefit them or afford them rights and defenses, and shall have all remedies of law or inequity in the event of a breach of this agreement. In the event that this agreement is terminated and fails to close due to the default of the party hereto, the defaulting party, you guys, your clients need to know this, the defaulting party shall pay as liquidated damages to each broker involved in the transaction an amount equal to the compensation each broker would have received had the transaction closed. That is where you get clients to not make emotional decisions when they understand that they cannot walk away from a $400,000 house because they're mad that the sellers were legally able to take the Ring doorbell because it wasn't checked off on the box on the disclosure. And so now they're mad and they're refusing to purchase the house. And then you remind them that the $50 Ring doorbell is not a reason to breach the contract. And if they think all they're going to lose is their $1,000 earnest money, they are wrong. They're going to owe both agents compensation. For purposes of determining the amount of liquidated damages to be paid by the defaulting party, all written agreements establishing the amount of compensation to be paid to any broker involved in the transaction are incorporated herein by reference. Additionally, upon the request of any party to the transaction, the broker shall disclose in writing the compensation they will receive when the transaction closes, so that the party knows the exact amount of liquidated damages they will be obligated to pay should the party default herein. So this is another thing that keeps coming up now that different parties are paying compensation and all of that's kind of changed, is listing agents are demanding buyer brokerage agreements. I want a copy of your buyer brokerage agreement. Does a listing agent have the right to a copy of your buyer brokerage agreement to prove the amount that you are asking the seller to offset? No.
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 Not even if they're asking for that money.
Huh?
Not even if they're asking for that money.
No. What they can do is request the broker put in writing what is the compensation amount. So you don't get to see my buyer brokerage agreement, but the broker can send you an email verifying what the amount is. So that's been a hot topic lately. And there are some companies, new construction companies, that think that they can demand copies, that they are not a party to that contract. They don't have a right to it. Even though they are asking the seller to offset it, they do have the right to have the broker verify what that amount is within the buyer brokerage agreement, but they don't have a right to the buyer brokerage agreement.
That's a good question.
Uh-huh.
I know sometimes you put 2.5 or sometimes you put 3%, but if, for the new bills, they give 3% or whatever. If I already signed with my client, my buyer or whatever, can I put 2.5 to 3, or it just needs to be 1%?
You can say up to 3,
Okay.
but even if you put up to 3, that's not going to cover you either.
Because they think they can choose
Yep.
the number. Got it.
So it has to be a finite number. What I would do is a special stip that if they do new construction, these are the terms that I will do them under. This is the percentage, and this is the max broker bonus that I'm allowed to accept, and include all of that in a special stip is what I would do. Attorney fees. In any litigation or arbitration arising out of this agreement, including but not limited to the breach of contract claims between the buyer and seller and compensation claims brought by a broker, the non-prevailing party shall be liable to the prevailing party for its reasonable attorney fees and expenses. Risk of damage to property. Seller warrants that at time of closing, so your sellers need to know this, the property and all items remaining with the property, if any, will be in substantially the same condition, including conditions disclosed in the seller's property disclosure statement or seller's disclosure of latent defects and fixtures checklist, as of the offer date, except for changes made to the condition of the property pursuant to the written agreement of the buyer and seller. Notwithstanding the above, if the property is destroyed or substantially destroyed prior to closing, the seller shall promptly give notice to the buyer of the same and provide buyer with whatever information the seller has regarding the availability of insurance and the disposition of any insurance claim. Buyer and seller may terminate this agreement without penalty not later than 14 days from receipt of the above notice. If buyer or seller do not terminate this agreement, the seller shall cause the property to be restored to substantially the same condition as of the offer date. The date of the closing shall be extended until the earlier of 1 year from the original closing date of closing, or 7 days from the date that the property has been restored to substantially the same condition as of the offer date, and a new certificate of occupancy, if required, is issued. So that's what you're going to follow if, like, let's say you're under contract and the house catches on fire. The parties are going to decide, are we going to move forward? Other provisions. Condemnation. Seller shall, 1, immediately notify the buyer if the property or a portion thereof becomes subject to a condemnation proceeding, or if seller has received notice of a pending condemnation proceeding, and 2, provide the buyer with all written communications regarding the same. Upon receipt of such notice, the buyer shall have the right, but not the obligation, for 7 days thereafter to terminate the agreement upon notice to the seller, in which event the buyer shall be entitled to a refund of all earnest money and other monies paid by the buyer toward the property without deduction or penalty. If buyer does not terminate the agreement within this time frame, the buyer agrees to accept the property less any portion taken out by the condemnation, and if buyer closes, the buyer shall be entitled to receive any condemnation award or negotiated payment for all or a portion of the property transferred or conveyed in lieu of condemnation. Consent to share non-public information. The buyer and seller hereby consent to the closing attorney preparing and distributing an American Land Title Association, that's your ALTA, estimated settlement statement combined, or other combined settlement statement to buyer, seller, brokers, and brokers-affiliated licensees working on the transaction reflected in this agreement for various uses. So that is the way that you are allowed to get a copy of the closing statement.
Wait a minute. Can we go back to condemnation?
Uh-huh.
I mean, what is that actually? I mean, is that condemned property?
Yes, and sometimes
So
it's
why would you buy condemned property?
well, and maybe you're buying 15 acres and this last acre over here is part of a condemnation whatever, and maybe you say, I still want the rest of it. Then, and let's say that the county is going to pay $10,000 for whatever that is, that then goes to the buyer because that was part of what they were purchasing.
Okay.
Yeah, but they do have the right to not move forward with it. It basically is going to be up to the buyer and seller on if they're going to move forward with it. So, but if the buyer wants out, they can get out and they can get their earnest money back. But if they don't, they can.
Money back too? I mean, is that what that's saying, that you get all your monies back that you spent, like inspections, termite inspection?
Where does it say that?
The buyer
Shall have the right to terminate.
other monies
Entitled-
paid by the buyer toward the property without
Without deduction or penalty. Well,
refund of all.
and I don't know that would be, I mean, that's a good question, I guess.
Because it says earnest money and other monies.
Which I would construe as a broker would be deposits of sorts, not, but could it be interpreted that way? It probably could. So that's a good question that I don't have the answer to. I could ask Seth. Seth Wiseman helps write them. He's GAR's attorney. Will you mark that, and I'll mark it and send an email? Delays caused by emergencies. So this is super important. If at any point, this is a newer, not that new this year, but newer. If at any point after, you need to highlight after the binding agreement date, the governor of Georgia declares a state of emergency for the county for which the property is located, all unexpired time deadlines herein, including but not limited to the closing date, shall automatically extend for the number of days the emergency exists in that county, but not more than 8 days. Nothing herein shall prevent the parties by mutual agreement from proceeding forward without extending such deadlines. No deadline shall be extended if this agreement becomes a binding agreement during the state of emergency. So I had lots of questions about that. We were already in the state of emergency and we're going binding tonight. Can we still extend? No. If you go under contract while it is already under the state of emergency. So what are things to think about? Power outages means you probably don't have internet. You may not have cell service. If you have a 5-day due diligence period and they cannot inspect the house and you have no internet, how are you going to send a termination notice? If the roads are iced over and they've shut the county down, you can't drive it over. You can't hire somebody to go drive it over. So you need to think of those things through before getting one of your clients under contract during a state of emergency. Digital signatures. For all purposes herein, a digital or facsimile signature shall be deemed the same as the original signature, provided, however, that all parties agree to promptly re-execute a conformed copy of this agreement with original signatures if requested to do so by the buyer's mortgage lender or any other party. So they can request wet signatures. Duty to cooperate. All parties agree to do all things reasonably necessary to timely and in good faith fulfill the terms of this agreement. The buyer and seller shall execute and deliver such certifications, affidavits, and statements required by law or reasonably requested by the closing attorney, mortgage lender, and/or title insurance company to meet their respective requirements. Entire agreement modification and assignment. Except for any pre-showing compensation agreement or any other separate agreement for the payment of the broker's compensation that is not part of or amended by this agreement constitutes the sole and entire agreement between all the parties, supersedes all prior written and verbal agreements, and shall solely be relied upon by the buyer. Wait a minute. I really need to bring my glasses, huh? Be relied upon by the buyer and binding upon the parties as if and their successors, heirs, and permitted assigns. No representation, promise of inducement, not included in this agreement or the other documents referenced above shall be relied upon or binding upon any party hereto. This agreement may not be amended, deemed to have been mutually departed from or waived except upon the written agreement of buyer and seller. Any agreements to terminate this agreement or any other subsequent agreement to the parties relating to the property must be in writing and signed by the parties. This agreement may only be assigned SS 611, that's our special step, or listed for sale in a multiple listing service by the buyer prior to closing with the written approval of the seller, which may be withheld for any reason or no reason. That means unless there is a right to assign, then there is no right. And the seller does not have to grant the right. Any assignee shall fulfill all the terms and conditions of this assignment, including but not limited to the obligations to pay the compensation owed by the assignor. Extensions of deadlines. No time deadline under this agreement shall be extended by virtue of it falling on a Saturday, Sunday, or federal holiday except the closing date. If you have 3 days due diligence that starts on Friday, you have Saturday, Sunday, and Monday. And if Monday is a holiday, then you have no business day at all, but your due diligence period will be up on Monday, even if it's a holiday. FERPTA affidavit. So this is something that has always been involved in closings. They have added it as something that buyers and sellers sign with the attorney. They have now made it part of the purchase and sale agreement. Unless seller is a foreign person, as that term is defined in section 1445 F3 of the IRS code, seller shall deliver to the closing attorney at closing a FERPTA, which is a Foreign Investment Real Property Tax Act affidavit indicating that the seller is not a foreign person. If seller is a foreign person, additional taxes may need to be withheld at closing. GAR forms, how are we doing on time? We have 20 minutes. The Georgia GAR issues standard real estate forms. These GAR forms are frequently provided to the parties in real estate transactions. No party is required to use any GAR form. These forms are generic and written with the interest of multiple parties in mind. Unlike your new construction. These parties agree to carefully review, the parties agree to carefully review the GAR forms to be used in this transaction and modify the same to meet their specific needs. So you are allowed to change it, but it's about to tell you how. If any party has any questions about the rights and obligations under the GAR form, they should consult an attorney. Provisions in the GAR form may be subject to differing interpretations by the courts other than what the parties may have intended. Our courts may at times strike down and not enforce provisions in the GAR forms as written. No representation is made that the GAR forms will protect the interest of any particular party or will be fit for any specific purpose. The parties hereto agree that the GAR forms may only be used in accordance with the licensing agreement of GAR. While GAR forms may be modified by the parties, no GAR form may be reproduced with sections removed, altered, or modified unless the changes are visible on the form itself or in a stipulation, addendum, exhibit, or amendment thereto. If there is something about the GAR form that both the buyer and the seller want to strike through the pre-printed part, that's exactly what they would do, is strike through it so that it is very clear to everybody. They cannot delete a paragraph and then make a copy of it and move things up and around, and then it's just gone out of there. Whatever is changed has to be very visible to everybody. Governing law and interpretation, this agreement may be signed in multiple counterparts, each of which shall be deemed to be an original and shall be interpreted in accordance with the laws of Georgia. No provision herein by virtue of the party who drafted it shall be interpreted less favorably against one party than the other. All references to time shall mean the time in Georgia. So if you're working with people in California, Georgia time is your contract. If any portion herein is held to be unenforceable, it shall be severed from this agreement, while the remainder of the agreement shall be, to the fullest extent permitted by law, continue to have full force and effect as a binding contract. So a judge may strike through a portion of something if they found it unlawful, and still hold the rest of it as a complete and binding contract. No authority to bind. No broker or affiliated licensee of the broker, by virtue of this status, shall have any authority to bind any party hereto to any contract, provisions therein, amendments thereto, termination thereof, or to notices signed by broker, but not the party. You guys do not have the authority to terminate a contract. It has to be signed by the client. However, if authorized in this agreement, the broker shall have the right to accept notice on behalf of the party, but not send notices from the broker on behalf of the party unless they are signed by the party. Additionally, any broker or real estate licensee involved in this transaction may perform the ministerial act of filling in the binding agreement date. Let's read that one more time. Any broker or real estate licensee involved in this transaction may perform the ministerial act of filling in the binding agreement date. So if you have a buyer who sends an offer, the seller signs the offer, and it is delivered back to the buyer's agent, is it binding? Is it binding if it's missing the binding agreement date? Yes, it is. Yes. The binding agreement date is a ministerial act, and the act of creating the binding contract is both the buyer and the seller have signed it, and it has been delivered back to someone, either the buyer or the buyer's representative who is authorized to accept notice. So, what happens if, for some reason, there are companies who are putting listings in the MLS, they will not sign a contract, blah, 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 whatever. So let's say buyer and seller sign, agent one, buyer's agent signs, but seller's agent doesn't sign, and the seller sends it back to the buyer. Is it binding? Did you guys follow that one? So the buyer submits an offer to the seller. Seller signs it. Seller's agent does not sign it. Seller sends it back to the buyer's agent. Is it binding?
Yes.
Yes.
Because only the seller and the buyer have to sign.
Yep. In the event of a dispute over the binding agreement date, it shall be resolved by a court arbitrator having the jurisdiction over the dispute by the written agreement of the buyer and seller, or by the holder, but only in making a reasonable interpretation of the agreement and dispersing earnest money. So, does the binding agreement date need to be filled in? Yes. That is the timeline that starts everything. From your due diligence, your earnest money, when it's due, your financing contingency. It must be filled in. What happens if, and this has happened, so buyer sends over an offer, let's just say on the 10th. Seller signs the offer and fills in the 11th and sends it back on the 10th. What's the binding agreement date?
The 11th.
12.
The 10th?
The 10th. Yep, the date that it was delivered back is the binding agreement date. So you guys need to check the binding agreement date and make sure that it is the correct one. And if it is not, then you need to discuss it with the other agent and say, hey, this isn't the binding agreement date. Because what can happen? I'd be like, my agent's or my buyer's getting ready to go on a 3-day vacation. And so I'm going to start the binding agreement date in a couple of days. Nope, that's not how it works. The delivery back is what makes it binding. That is notice from the seller to the buyer that they have accepted the terms that were offered to them. Sometimes you have to get your broker involved. That's an okay thing to do. Like, get your broker involved. Be like, hey, you need to fix this. What are we going to do? We're going to look at email traffic. You're going to have to prove it. And then I'm going to look at dates and times that the emails were sent. And then I'm going to cross through it. And then I'm going to initial it with the actual binding agreement date. Objection to binding agreement date. If the buyer and seller object to, did we already read that? No. If the buyer and seller objects to the date entered as the binding agreement date, then within 1 day of receiving notice of binding agreement date, the party objecting shall send notice of the objection to the other party. So you don't have the entire contract to dispute it. When you get it back, that's when you get to dispute it. You have 1 day. The objection shall be resolved by the written agreement between the buyer and seller by executing a binding agreement date confirmation, which is an F733. The absence of an agreement on the binding agreement date shall not render this agreement unenforceable. The failure of the party to timely object will result in the parties accepting the binding agreement date as entered. If you don't object to it within 1 day, that is now your binding agreement date. Property to be delivered in clean condition. This is one of the worst ones. I hate this. Why do I hate this? Notwithstanding, yes. Notwithstanding any other provision to the contrary, at the time of possession, the seller shall deliver the property in clean condition, free of trash, garbage, debris, construction material, pets, and personal property of the seller not otherwise identified in this agreement remaining with the property. Firewood shall not be considered debris. That's a new thing for this year. This section shall apply even in transaction where the property is being sold as is. So, what is clean? I guess it depends on who you're talking to, right?
Well,
Boy.
It says no trash. That helps.
Right?
I mean, I've seen trash houses get sold, though. That's what I'm surprised. But
Well-
they knew it was, like, they knew that they would have to fix it and stuff.
Psst.
Now they have
This section shall apply even in transactions where the property is being sold as is. Yeah, so now they could add a special stip that says all parties agree that all of the trash in the house is staying, but the buyer would need to know that up front. But other than that, I would be standing on all of this trash either gets removed or we're hiring a company and I'm going to get their estimate over here and we're going to withhold it out of your closing. And then it's going to be paid that way. So you choose, I don't really care, but it's going to be gone.
One more question about that is that what about banks seize houses where their stuff is still in the house? Do the banks have to clean it out? Or
Yeah,
do
the
they
banks will
still-
clean it out.
Really?
They're not going to list a house with personal property in it.
Well, they have.
They did. I was gonna say, they
do.
definitely did.
They don't care.
A bank did?
They
They didn't pay for a clean out?
No, they did my aunt's
They
house.
had
It was
personal property in there?
sofas, beds, everything. We didn't
Bank
even know it
statements.
happened.
Well, and that was my next thing was like the amount of, social
Yeah.
security numbers, boy. Rules for HUD houses won't do that. Rules for interpreting this agreement. In the event of internal conflicts or inconsistencies in this agreement, the following rules for how those conflicts or inconsistencies shall be resolved will apply. 1. Handwritten changes shall control over pre-printed and typed provisions. So if you handwrite it, it will prevail over anything else that is in there. Exhibits control over the main body of the agreement. If there is an exhibit that says one thing and this purchase and sale agreement says another, the exhibit prevails. Special stipulations shall control over both exhibits and the main body of the agreement, including handwritten changes thereto. Special stips control. Notwithstanding the above, the amendatory clause in the FHA and VA exhibit shall control over inconsistent and conflicting provisions contained elsewhere in this agreement. This is super important. So what was happening when everybody was going over asking price with an FHA or a VA loan, and then the appraisal comes back and the buyer says, nope, even though we have a special stip that says that I'm going to pay $10,000 over, I'm not going to do it.
Well, you are.
Nope. FHA, then that's why this is important to know. FHA or VA exhibit shall control over inconsistent or conflicting provisions contained elsewhere in this agreement. The buyer and seller acknowledge and agree that the agreement to seek amendment to purchase price prior to termination section and the FHA or VA exhibit does not conflict and is not inconsistent with the amendatory clause. So when you say that you're going to pay $10,000 over, can they? Yes. Do they have to? No.
Even if the seller,
even if they agreed to pay, over an appraisal amount. And so that's super important for your sellers to know that the FHA amendatory clause is what is going to prevail. So could they? They could, and they did sometimes, but when they argued it, at the end of the day, the FHA prevailed. The amendatory clause. Except as otherwise provided herein, this agreement and any amendment thereto shall be enforced as between the parties, even without the signature of any broker referenced herein. Notwithstanding the above, if any provisions in this agreement, including the provision in any amendment thereto, changes the total amount of compensation due to any broker from the total amount of compensation said broker had previously agreed to in writing, then such change to the broker's compensation shall only be binding if the broker impacted by such change consents to the same in writing. That means if you have a compensation agreement that the seller is going to pay 3%, and then whatever happens, and now the agents have both agreed to, and I'm saying these as examples, not what to work for. And then the agents have agreed to go down to 2.5% each. The broker has to approve that in writing. If the buyer's broker compensation exhibit is attached as an exhibit to this agreement shall not be enforceable unless this agreement or such buyer's broker compensation exhibit is initialed by the buyer's broker, and in cases where the seller's broker is sharing a portion of the compensation with the buyer's broker, the seller's broker. So you as a listing agent, let's just say for an example, that you have agreed to list a property for 5%, and then the seller agrees to do a bunch of stuff over here to fix the house, but now he's only doing it if you reduce it to 4, you cannot then go and change the other agent's percentage to 2 without their authorization. If broker has written any special stipulation herein, The party for whom such special stipulation was written, A, confirms that each stipulation fully and accurately reflects the party's intentions. B, accepts each special stipulation as if it were written by the party. And C, hereby agrees to indemnify and hold the broker who prepared the stipulation harmless from any and all claims, causes of action, suits, and damages arising out of or relating to such special stipulation. This is putting the buyer and seller on notice that if special stips are written in the contract, they need to read them and make sure that they agree with them, that that is exactly what they wanted them to say. If the broker answers a question of buyer or otherwise describes some aspect of the property or the transaction, broker is doing so based upon information provided by the seller rather than the independent knowledge of the broker, unless the broker makes an independent written disclosure to the contrary. So one of the things that I always do is they'll ask a question, what is the amount of the utilities? And we'll go to the seller and the seller will reply $250. I don't go back and tell the buyer $250. I say the seller says that the utilities are $250. Always make sure that you are very clear who the information is coming from and that it's not coming from you. Because if they turn out to be something different, who's the first person that they're going to come after? You, unless you tell them, it's not my information. I'm not telling you $250. The seller is telling you $250. What do we got here? 2 minutes. Oi. Well, sorry for all of my stories.
No, no. Stories are the important part.
Okay, statute of limitations. They changed this. It used to be 3 years. Then it moved to 2. Now it's down to 1. Yay. Survival of the agreement. Time is of the essence. These are just definitions. We're not going to go through those. Cyber fraud. Please make sure that you read this and you are very prepared to explain how cyber fraud works to all of your clients, both buyer and seller. And then,
We'll explain it to them.
good. Heightened identification procedures to help prevent fraud. Please read through that. We're not going to have time to, but there is a lot of people who, well, I say a lot of people, there is a lot of fraud going on. Let me tell you, back to my stories. Let me tell you how it's happening. I got a call from a lady who said, I live down in Florida and I just drove by my property in Macon and you have a for sale sign in my front yard. And I was like, okay, who's listing your property? And she says, I'm not listing my property. And I said, well, that sounds pretty strange. Let me find out who's listing this property. So I pull up the property in our paperless pipeline and I say, oh, this is the agent that's listing the property. And she says, ma'am, I'm not selling my property. I don't know how else to tell you that. Why do you have a sign on my property? Okay, this is getting kind of intense. So I go and I look at our listing agreement. And let's just say, for the sake of the story, her name is Susan. And I look at the listing agreement, and it's signed by Mike. I'm like, well, my listing agreement is signed by Mike. She said, well, I'm not Mike. I'm Susan, and this is my property. And why do you have a listing agreement with somebody else and a sign on my property? So I'm like, one of the things that we require our agents to do is upload the legal description. So I pull up the legal description that's sitting right there. I'm like, what did you say your property was? 123 Main Street? I'm looking at 123 Main Street tax records, and Mike owns this property. What did you say your name was, Susan? Oh, Susan, I'm looking at the tax records, and you sold this property to Mike. I mean, not to Mike, to, let's say, James. And James sold it to Mike. She's like, I have no idea what you're talking about. This is my property. So here was the fraud. Vacant, which people can figure out. A lady went around. She closed on 5 properties in one day at one closing attorney, and then went to several other, closing on several. When I say hundreds and hundreds and hundreds of houses, they had so many warrants of arrest in so many different counties all over Georgia for this lady. So she takes a vacant lot, sees it, does this like a mail away. So all of the closings are done with a seller who signs somewhere else, doesn't come to the closing table. Do you know that she closed with a closing attorney in Macon on 5 properties in one day? Each of the properties had a mail away, so no seller at the table. She bought every single one of them for $1, and there was no red flags that went up. How did that even happen? So she sells them to, let's say, George. George sells them to our client, and it's all in the tax records. Like, my client owns the property. Yep, stolen right out from under her. So the second time that I talked to her, she was like $30,000 into trying to get her own property back. Mm-hmm.
Like recently.
Yeah.
Bridget says now that
Title insurance
you have to
come in
go
at that
to,
It does if it had been insured, but
but yeah, they have to, they don't do mailaways anymore unless you go to one of their known attorneys to notarize them.
I got you. The only other thing I was going to note on here, which I already did, make sure that you're checking your boxes. If they are not checked, even if you put Exhibit C for your special or for your seller's property disclosure, it has to be checked. Make sure the back is filled out in its entirety. And I say in its entirety for your information. You're representing the buyer's signature and their name and their date is on there. Does the address for receiving notice, what would that be?
Email.
Your email. Not theirs. Do you have to put the buyer's information on here, their phone number, the buyer's phone number, the buyer's email? Do you have to put that on a purchase and sale agreement? No. Now, there are some brokerages who will require their agents to put that information on there. Let me tell you why I don't like it. At the closing table, they're not your clients anymore. And so any agent can go talk to them. And one of the things that I used to do after we had a closing, I would have my copy of it and I would make a second copy of the closing statement, and I would put them in 2 envelopes, and I would have the buyer and the seller's information, and I would mail them out every January for their taxes. Because guess what I'm going to try to do? I'm going to try to provide service. Don't give other agents your clients' information when you don't need to. The closing attorney will need it, but the other agent doesn't need it. And the buyer and seller don't need each other's phone numbers. So.
Can I ask a question?
Sure.
Apart from this class, what is the rules on investors buying properties? Is there a law that just came out? Because I have investors. They say they're not allowed to buy properties.
It's corporate
So,
investors,
yes,
right?
corporate
I mean, like,
investors.
big corporate.
They're buying
Yeah.
houses like Atlanta,
Like apartment buildings.
pricing people out.
And I've seen it. I know that it's going into effect. I don't know the details of it, though. Like, how big of a corporation does it have to be before you're not allowed to buy it? I don't know those answers yet.
They never makes close.
No, I think it got approved.
Like
But like I said, I don't know.
Yeah.
where they all fix the properties up and then the people have no recourse.
If you guys can sign out, please fill out your, I gave the things. Linda, before you go, I've got to get your stuff to put on here for the CE credit. And then please fill out the little questionnaire thing. GREC requires us to show that you guys feel free to put nice things on there. If you didn't like the class, still put nice things. I'm just kidding.
That's what you asked me to write.
Those.
Yes.
Oh, there.
Yes.
Anybody else need to sign?
Thank you so much.
You're welcome.